Sexual harassment can happen in any workplace, but licensed premises can face particular risks. Late-night working, alcohol, close contact with customers and an informal workplace culture can all increase the likelihood of inappropriate behavior. If a member of your team was sexually harassed by a colleague, manager or customer, could you demonstrate that your business had taken reasonable steps to prevent it? Pubs, bars, restaurants, hotels and nightclubs can present a combination of risks. Employees regularly interact with customers who have been drinking. Staff may work late at night, sometimes in isolated areas, and workplace boundaries can become blurred in informal or highly social environments. Hospitality also employs many young, temporary and casual workers who may be reluctant to challenge inappropriate behavior or complain about a manager. None of these factors excuses sexual harassment. However, they are foreseeable risks that responsible employers should identify and manage before an incident happens. Sexual harassment is unwanted conduct of a sexual nature which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment. It does not have to involve physical contact. It can include spoken comments, gestures, messages, images or online behavior. The person responsible might claim that they were joking or did not intend to cause offense. However, intention is not the only consideration. The effect of the conduct and whether it was reasonable for the behavior to have that effect must also be considered. A single serious incident may be enough to constitute sexual harassment. Sexual harassment can take many different forms. Examples include sexual jokes, comments about someone's body, intrusive questions about their private life or repeated requests for dates after the person has said no. It can include unwanted touching, deliberately brushing against someone, suggestive gestures or displaying sexual images. Harassment can also happen through staff messaging groups, social media, emails or private messages. Behavior does not become acceptable simply because it takes place during after-work drinks, a staff party or outside normal working hours. If there is a connection to work, the employer may still need to respond. The risks do not only come from other employees. Workers may experience sexual harassment from customers, contractors, suppliers, performers, promoters or other third parties. An employer should not dismiss inappropriate customer behavior as something staff must tolerate because they work in hospitality. Managers should make it clear that abusive or sexually inappropriate conduct will not be accepted. Staff should know how to obtain immediate assistance, and managers must be prepared to challenge or remove customers when necessary. Protecting revenue or keeping an important customer happy should never take priority over the safety and dignity of employees. Since the 26th of October 2024, employers have had a legal duty to take reasonable steps to prevent sexual harassment of their workers. This is a preventative duty. Employers should not wait for a complaint before taking action. They are expected to consider where sexual harassment could occur and introduce reasonable measures to reduce those risks. The duty covers harassment by other workers and also requires employers to consider risks created by third parties, including customers and clients. What is reasonable will depend on the organization, its resources, its working environment and the level of risk, but doing nothing is not a reasonable response. Simply downloading a sexual harassment policy and placing it in a folder is unlikely to demonstrate effective prevention. The policy should reflect the risks within the premises and explain prohibited behavior, how concerns can be reported and what action may follow. Every worker should understand the policy, including casual, temporary and agency staff. Managers require additional training because they may receive complaints and must know how to respond. The business must also enforce its standards consistently. If senior employees, popular customers or high-earning managers are treated differently, the policy will have little practical value. Training, policy reviews and management actions should all be properly recorded. Failing to prevent or properly address sexual harassment can have serious consequences. A worker may bring an employment tribunal claim. Where a successful sexual harassment claim is made and the employer has breached its preventative duty, compensation can potentially be increased by up to 25%. The Equality and Human Rights Commission may also take enforcement action. Beyond the legal consequences, the business could experience sickness absence, staff resignations, recruitment problems and serious reputational damage. Sexual harassment is primarily an employment and equality law issue. However, incidents involving violence, criminal conduct, vulnerable customers or poor management may also create wider concerns for the police, licensing authority and other regulators. So, what should operators do now? First, assess where harassment could reasonably occur, particularly during late-night work, customer interaction, staff events and lone working. Second, update your policy and make sure every employee understands it. Third, train employees and give managers additional guidance on preventing and responding to concerns. Fourth, provide safe reporting routes so workers are not forced to complain to the person involved. Finally, keep evidence of risk assessments, training, policy reviews and management action. These are starting points, not the complete solution. The detailed procedures must reflect the risks and structure of your own business. The question is not simply whether your business has a sexual harassment policy. The real question is, if an incident occurred tomorrow, could you prove that you identified the risks, trained your team and took reasonable steps to prevent it? Licensing professionals can help you review your compliance arrangements, while our Sexual Harassment Level 2 online course is available through Click to Comply. Visit our websites using the links in the description, and subscribe to the Licensing Professionals channel for more practical licensing and compliance guidance.